Good afternoon. Thank you so much for all of you taking time out of your day to join us for our webinar, The Coronavirus, COBRA, and More. My name is Casey Hope. I'm the Marketing Manager at Medcom Benefit Solutions, and I will be joined today by our Senior Legal Counsel, Michelle Barkey. Michelle has expertise in a wide variety of avenues. Not only is she a registered nurse, but she's also a lawyer and has a lot of experience with HIPAA, compliance, COBRA, and the legal system. I just want to go over a few things today as we get started. It's a reminder that this is being recorded, and we are going to be able to provide you with that recording and the slide deck once this presentation concludes. If you have further questions after that, please feel free to submit those to COVID-19 questions at medcombenefits.com, and we will answer those next Tuesday at 10 a.m. for our desktop discussion. I'll also send that information to you in the email provided with the slide deck and the recording of today's presentation. So we do have a lot of things to cover today. It's the reason why we are all here, is to have a lot of questions answered. So I'm going to go ahead and get started and turn this over to Michelle.
Thank you, Casey. And again, the topic that we're talking about today is the coronavirus. It has now affected COBRA and much, much more.
All right, I'm showing the agenda here. Michelle, did you want to go over any of those points?
Yes, please, Casey. And again, with the agenda, and it's where we began, COBRA and the coronavirus, special enrollment, and claims deadlines. And again, this information is intended to be just for informational purposes only. It does not constitute legal or tax advice. Things are changing rapidly, and when necessary, please talk to your legal counsel. Just a brief update on the coronavirus itself. I don't know if you realize, but the CDC has now come out with additional symptoms. Originally, they had just mentioned cough, shortness of breath, but now they're coming out, and fever, but now they're coming out with a few more. They're saying cough, shortness of breath, and at least two of the following: fever, chills, repeated shaking with the chills, muscle pain, headache, sore throat, and it seems to be a phenomenon that a lot of people are losing their sense of smell or taste. So those are the new corona symptoms that we must all be aware of. Back in the 90s, we talked a lot about a book that had come out, and it had been called Who Moved My Cheese? And it was basically a book that dealt with how to handle change. And with what we're going through with the coronavirus, never before have we had such a change in a rapid order of the laws being changed rapidly. At this point, we have had several changes in the law as it relates to the coronavirus. We have the Family First Coronavirus Act to begin with, and it just basically gave us paid 2 weeks of sick leave and expanded family medical leave, where for reasons related to the coronavirus, including the schools being closed and the daycare shutting down, individuals who were not able to work, including telecommuting, could potentially take paid leave, and then if after the paid 2 weeks sick leave, potentially they could also be entitled to expanded family medical leave. Also, we have the Disaster 139, Section 139, where since Donald Trump declared a national emergency, you can give tax-free monies to your employees through a Section 139 to cover a whole lot of items that they might need due to a disaster. OSHA has recently released some guidelines. They're not standards. You don't have to follow them, but they did give us some guidelines for a safe work environment as we all begin to think about potentially going back to our offices and leaving the safety and comforts of home. And then today we're going to be talking about something that just happened last week, which we've now got the expanded time frames for COBRA claims and special enrollment rights. And that's going to be the bulk of our presentation today. But we also had the CARES Act, and it gave us 100% leading to a diagnosis of COVID-19 is to be paid at 100%. So if you go into the emergency room with the symptoms and they're trying to stabilize you and then they are trying to diagnose whether this is COVID, that's all covered at 100% without a deductible or copay. And because of that, they had to make an accommodation for those high deductible health plans and said, even though this is going to, the deductible is now waived for COVID, it will not affect those high deductible health plans that have the HSAs attached to them. We know that we can now get over-the-counter medications and menstrual products covered under any of the Section 125s, HRAs, FSAs, HSAs. The employer has to approve that on the HRA or the FSA, but it is allowable now under the IRS regs. We got the Paycheck Protection Program for those employers who are under 500 lives, basically, generally, and that they could get some monies potentially to keep their businesses running and their employees employed during this pandemic. We had the Employer Retention Credit, which is for employers of any size, and it helps to provide them with some relief. And then we had the Section 127, which up until the end of this year does allow for some student loan repayments. So we moved the cheese, basically, since this pandemic has hit. And not only has it affected all our personal lives, but in this business, when we're doing with benefits, it has certainly affected the benefit plan. But today we're going to be talking about the extension of certain time frames. And this is going to be for all employee benefit plans and participants and their qualified beneficiaries. And basically what the Department of Revenue, and along with the Department of Labor with the IRS had said, is that they wanted to make it easier for certain individuals to continue to have health care benefits, but during this pandemic, when money might be tight. And they said, considering the national emergency, the departments state that the employers, employees, and dependents may have the difficulties meeting some time frames. They may not be able to get all their documents together. They have some issues going on. So basically what the government said is we are going to expand some time frames. It's mandated. You don't have a choice. What they did in order to do this is they established what they called an outbreak period. And basically what they said is the outbreak period will start from March the 1st of 2020, and it ends 60 days following the end of the national emergency. So when does it end? Officially, we don't know, because the national emergency has not been declared, has not had a declared ending yet, so it's still tolling. So basically they said that period of time, from March 1st to the end of 60 days following the end of the national emergency, that period of time does not count when you are counting certain time frames. So that is what we have to realize. This amount of time is actually what we call in the law tolled. It does not count, you don't consider it, and you calculate others because of that. So how does this affect the benefits? Well, it certainly affects COBRA in a big way because the government said it did. Now, as you all know, normally under COBRA, after that letter goes out to an employee who has been terminated or who's had a qualifying event, that employee typically has 60 days to get the form back and say, hey, I want COBRA, here's my election form. And then he has an additional 45 days after that in order to pay that first payment. And then after that, the premiums have to be paid monthly, typically at the first of the month, although some plans are different. And they do have a 30-day grace period, so they can be laid up to 30 days. Now, with this extension that the IRS and the Department of Labor have provided, that March 1st and 60 days past the end of the declaration of the national emergency, the end of the national emergency, that period is now carved out. So they don't have to pay, they don't have to elect until 60 days after the end of the national emergency, plus the 60 days they would normally have to elect. So we're talking about potentially going into October, maybe even November, depending on how long this national emergency continues. In addition, if you have an ongoing COBRA person on the plan, they have now got more than that 30-day grace period. They've got that whole period that's carved out, the 1st of March to 60 days at the end of the declaration of the national emergency, and then the 30-day break period, then the 30-day grace period will actually kick in. So again, we're talking potentially some people will not have to pay premiums for quite a long time. Historically, this is not the first time that we've seen this. Following Hurricane Katrina, the agencies issued regulations requiring COBRA notices mailing in election periods to be told between August 29th of 2005 and February 18th of 2006. So there was a little bit of a tooling there as well. But right now we're in this kind of flux in uncertainty era because we don't know when the national emergency is going to end. And for Hurricanes Harvey, Irma, and Maria, they didn't make specific rules, but they said the guiding principles for plans must be to act reasonably, prudently, and in the interest of the workers and their families who rely on their health plans for their physical and economic well-being, and for plan fiduciaries make reasonable accommodations. So during those 3 hurricanes, we did have to make some accommodations. If somebody was a little bit late and they said it was because of the hurricane, then we accepted that. But now we've got this breakout period, and it's nationwide, and it covers, as I said, March the 1st to the 60 days past the end of the national disaster being declared over. So COBRA challenges that you're going to have is, first off, the health plans and carriers do not have to pay the claims if the premiums aren't paid. There has been some guidance that they're not allowed to deny the claims, so they can't send out an official notice saying, hey, we denied your claims because the premiums haven't been paid. But they have to be able to keep the claims in abeyance and then track the monthly payments so that when the monies come in, then they can start paying those claims. So, you know, some might decide to what we used to call pay and chase, where they might say, okay, I'm just going to pay it, and then if the premiums aren't paid, then we'll chase the refunds. But I don't think many carriers are going to do that. But this is going to be a challenge in the COBRA world. And again, as we mentioned, claims cannot be denied during this period of time. Again, it's like these days didn't even exist in this outbreak period. Everything just stops until those premiums get paid, and then the medical claims can be paid. I can see the providers getting very upset. They want their money. They've, especially the ones that are coming back to work now and doing some elective surgeries, and all of a sudden the payments aren't coming in. And even those who have worked tirelessly during the COVID virus and working in the hospitals, and all of a sudden their payment seems to have stopped as well. So as typical in COBRA in certain circumstances, we see third parties paying the COBRA premiums, i.e. the hospitals or providers, and we might be seeing more of that in the near future. Again, one of the things that is going to be really challenging with all of this is it's the unknown. We do not know when the pandemic is going to end. And again, it's from March 1st to 60 days to the end of the national emergency. And we do not know when that date is. So it's going to be very hard to tell employees or the qualified beneficiaries when they actually have to have their monies in. We are making a date that will be known, and again, that might have to be changed. But right now, it's kind of arbitrary. And this is going to be one of the most difficult things as to how do we convey this to qualified beneficiaries. I do want to mention at this point that we also this week did have COBRA model notices change. And the Department of Labor came up and they said, we've changed the COBRA model notice. And, you know, at first glance, everybody thought it would have to do with these outbreak rules changing and these timeframes changing. But the DOL did not touch that when they did the model notice change. If you look through the model notice, you will not see anything about the coronavirus. You will not see anything about a national emergency. You will not see anything in the new model notice about the outbreak periods. And you will not see anything about tolling any kind of benefit until after 60 days following the end of the national emergency. What they changed was they enhanced the definitions and the explanations as to how COBRA and Medicare interact. So it happened at the same time, but it did not affect, the COBRA model notices do not include any of this. And again, it would be difficult for them too, because first off, it is limited to this time frame. It's not going to go on for the rest of the time unless a national emergency goes on. And again, we do not have a date certain when the national emergency is going to end. So how does this affect COBRA? Well, we know that you have at least 60 days to elect COBRA and the continuation of coverage. So let's go into an example that was provided. Tony experienced this a qualifying event due to a reduction of hours because of the COVID-19. And she experienced this on March the 17th. Assuming the end of the national emergency is April the 30th, the outbreak period would then end on June 29th, and thereafterwards, Tony would still have the 60 days to elect the coverage for August 28th of 2020. So again, that would be 120 days after the end of the national emergency, and we don't know when that is ending. So that is one of the changes that we do have. Now, the payment of COBRA premiums, we know that an individual has to pay them monthly, and we know that they have to be paid within the grace period, which is typically 30 days. So here was another example that was given, and it really does explain the tolling, where it doesn't have to happen after March 1st for this law to go into effect. What it does is it just tolls that period. It puts a suspension into the whole equation, but the event doesn't have to occur at March 1st or afterwards. And the example they gave was Tony began receiving benefits of the COBRA on January 1st, and the payments are due monthly at the first day of each of the months. So she paid her premiums for January and February, but she did not pay March. Well, March 1st is the beginning of the outbreak period, and she has till 60 days past the end of the end of the national emergency, and then she has the 30 days. So assuming the end of the national emergency was again that April 30th, the outbreak period would end on June 29th of 2020. Then she would have an additional 30 days to pay her premiums. But now she would owe March, April, May, and June, and July. And so again, she has that time to pay during this period of time. So again, you have to look at 30 days past the end of the national emergency is when she would have all the back payments. And because the July payment in this case is not due during the outback period, the deadline for this would not be extended. She would still have the 30 days. So it's going to get very, very confusing very, very quickly. Well, we also have this outbreak period for special enrollment rights. And we all know what the special enrollment rights are. If there's a family change, marriage, or having a baby, or adopting a child. And it could also be for coverage changes, like you've lost your spousal coverage. And typically under special enrollment rights, you have 30 days to make a change of benefits or to enroll the child or the new baby. But again, this is now going to be told. And again, the outbreak period is the same, March 1st through 60 days past the end of the national emergency. So the individual would have any time 30 days after the end of the national emergency to actually enroll the child. So, or to change the benefits if they had a loss of spousal coverage. So again, you just take this period of time, carve it out, it doesn't exist, and then calculate the days that they actually have. Okay, so an example. Mary has a baby on March 1st of 2020, the very beginning of the outbreak period. Typically, she would have 30 days to decide if she wanted to enroll the baby in the plan or change plans even. Since the baby was born on March 1st, she would now be in the breakout period, and she would have between March 1st and 60 days past the end of the national emergency, plus the 30 days to decide whether or not to enroll the child in health care coverage or to change her coverage. But what if the baby was born before the end of that beginning of that March 1st, before the breakout period commenced? What if the baby was born on February 15th? Well, February had 29 days this year, so therefore she used 14 days in February. The breakout period would then toll the time she would have, and then she would have 16 additional days after the end of the breakout period. So even if the event happened before the breakout period commenced, as long as it wasn't more than the 30 days, whatever she had before, it counts, then it gets tolled, and then the balance gets picked up at the end. So again, typically with a loss of coverage, you have the 30 days. And again, the example provided is Tony loses the eligibility to participate under her spousal plan because coverage under that plan ended on March 31st. Assuming the announced end of the national emergency is April the 30th, which we know it's not now, the outbreak period would end on June 29th. And therefore, the deadline for Tony to request enrollment is now 30 days after that, which is July 29th, or 90 days after the national emergency ends. So again, she's going to have a lot of time to do this. And then again, as we talked about, a new baby. Tony gives birth on February 15th. She would like to enroll the child in the health care plan. Assuming the announced end of the national disaster is April the 30th, she would have to elect to have coverage for her child is July 15th, because she had 14 days before the outbreak period started, and then she would have 16 days, 60 days after the end of the national emergency was declared resolved. So again, we're going to have to watch those time frames, and it's again just told, and we don't count them. Well, this is also going to toll claims as well. Certain claims have deadlines. And what's the impact going to be on the claims before we talk about the claims? Well, if you're a self-funded group and you need your IBNR, that breakout period, you're not going to be getting the claims submitted. So you may have more claims incurred than have yet to be reported because of that breakout period being told. And then the reconciliation for FSAs and HRAs are also going to be extended because that run-out period is going to be told after March 1st, 2020, through 60 days past the end of the national emergency. And then after that, whatever days they didn't use in the run-out, they would be able to get that in post 60 days after the end of the national emergency. So again, it's going to affect claims as well. So what's the claims deadlines? Well, a lot of the times the insurance companies and employers set timeframe submissions of claims. Typically, it's 365 days after the time that the claim was incurred. And flexible spending accounts, as we mentioned, usually have a run-out period at the end of the year, usually 30 to 90 days. Sometimes even after an employee terminates, they will have a run-out period. The new extension also impacts this because now you have to toll the period between March 1st, 2020 and 60 days past the end of the national emergency. So if the plan has 365 days to submit a medical claim for medical care, and Tony received medical treatment under the plan on January the 1st, assuming the announced end of the national emergency was April the 30th, the outbreak period would end on June 29th, and therefore is 121 days. The deadline for submission of the claim is May the 1st of 2021, because she had 59 days before the outbreak period, and then she had the outbreak period when the days didn't come, and then she had 306 days after the outbreak period in which to submit the claims. So again, our IBNRs and our run-out periods are going to be really extended this year, and we're going to have to really take that into consideration. But it also affects the appeals on disability plans as well. The plan procedure set in the claims typically is that you have to have to make any appeal within 180 days upon receipt of the adverse determination. And again, that is now going to be told for that period of time as well, so that if somebody comes up with an appeal and the appeal is late, if it's timely after you've carved out the outbreak period, then you're going to have to consider the appeal. And this could also affect anything else that has pension plans and others. Plan designs and claims procedures set the deadlines for filing an appeal on an initial claim that could be cannot be less than 60 days following the receipt of the adverse benefit determination. And now we have to look at that outbreak period as well. So again, it's going to affect these time frames are going to affect appeals, they're going to affect claims, they're going to affect special enrollment rates, and then it's really also going to affect COBRA. And it's going to be interesting to see how it all comes together. Again, there's not a lot of guidance right now, especially when it comes to COBRA and how beneficiaries are noticed on this. MedCom is preparing a few flyers that we will get out by the beginning of next week to our broker partners and employers. But again, these time periods are going to be very, very important. Again, whenever you look at the extensions, you look at March 1st of 2020, plus the 60 days from the end of the national emergency. We do not have an end in sight at this point, so we can't tell you how long it's going to be. Then you count the days that is typically standard, i.e. COBRA 60 days to get the eligibility, to get your election in. So after the end of the national emergency, that's when the 60 days would start, unless you use some of those days beforehand. So again, we have to look at that whole chart and knowing what we're doing in that carve-out period. In summary, we went through the laws that have changed already. We're only on May 7th today. The national emergency was declared on March the 13th. We've been through the Families First Coronavirus Response Act. We've been through the CARE Act. We've got Section 139. We've got sections for the emergency disaster relief payments that we can make. We've got 127 for student loans. We've got, the paid family leave, and we've got the 6 weeks for 2 weeks because of the coronavirus. Lots have changed, and the laws are changing rapidly. And again, as we saw, the extensions came out last week. So it's really important that we all keep track of what's going on. We believe this year is going to be a year of discretionary enforcement as far as certain things pertaining to cafeteria plans. So we need to make sure that we follow the rules as best we can. And if we're bending the rules in any which way, we document that we're doing it for the benefit of the plan participant, and that we're not doing it to avoid paying taxes or anything else. But this year has been a year to remember, and we certainly are going to have to keep track of what's coming out there and the new laws. Take it one step at a time and certainly stay informed. Now, Medcom Benefit Solutions, most of you know, we do have a lot of products, and just to go over them briefly, we do ACA employer reporting and penalty appeal support if you get one of those lovely IRS love letters. We do have consumer-driven health plans, which are the FSAs, HRAs, HSAs, and they are, that department is aware of these extensions of times and are putting in together policies and procedures in order to account for them. We also do COBRA premium billing and administration, and our COBRA department is already on top of all these changes. And as we mentioned, COBRA also dealt with a change in the model notice this week, and we have updated our notices that we provide to include all the Medicare language that the model notice has now put in. But none of this was in the model notice because it is really just a temporary tolling of the hours. We do HIPAA privacy and security. We have a lot of security solutions. And then, of course, we do health and welfare compliance and actuarial services. So if you need any help with 5500s or anything, then go ahead and contact your sales rep. Just to let you know, the 5500s are still going to be due July 31st. That has not changed if you were a calendar year plan and you meet the requirements to having to file a 5500. That deadline has not shifted, and it is not part of this tolling process. So if you have any questions, please don't hesitate to contact me. I'm at mbarkey@medcombenefits.com, and I am Medcom Senior Legal Counsel.
Thank you so much, Michelle. We are going to open it up for questions at this time, and questions we do have. I'll tell you that we knew we were going to get some questions about this today, so we're going to try to answer those as best as we can. Starting from the very beginning, some of the questions that we got earlier on in the presentation. If the employee termination is not COBRA related, does this apply?
If it's not COBRA related and they don't have a COBRA because it's not a qualified beneficiary, or they don't have a qualifying event that leads to COBRA, then this would not apply. It only would apply to those that are actually eligible for COBRA.
Does under COBRA, does this cover all group sizes or just employers of 20 and more employees?
That is an excellent question, and as far as we know, this at this point is we're talking about the federal law, the federal COBRA law. So it's 20 or more employees. State continuances, some states have made special mandates because of the coronavirus. I know Ohio, for an example, said you couldn't charge premiums until afterwards. But if you have under 20, check your state continuation rules to see what applies. This presentation and these rules were specifically for federal COBRA.
Thank you. Do COBRA clients of Medcom benefits have to do anything to comply, or will Medcom take care of the COBRA administration entirely?
Medcom will take care of the COBRA administration. We've already got processes in place to do the tolling. The questions that are still up in the air are basically, how do we notify the employee that they don't have to pay the premiums, or do we just wait, put them in abeyance until afterwards? We're still waiting for some clarification from the federal government as to how this is going to all come down. But at this stage of the game, Medcom will take care of it for Medcom clients.
If we're a Medcom client, can we tell Medcom to terminate someone within the previous COBRA rules and then the person be reinstated if they pay their premium according to the new rules?
No, you cannot terminate somebody. If somebody terminates the employment, that's great. We will send out the notices that say you have 60 days to send us in whether or not you're electing. However, we will not, if they send it in late, we will not deny it under these rules. So that will continue as normal. But this is a mandate. We have no choice that this breakout period is still going to apply.
Okay. Do employers have any options with the FSA deadlines, or is this mandatory for all plans?
The FSA guidelines, if you have a run-out period, it is going to toll that run-out period. So you don't have a choice there. It's going to be mandatory for all plans. This is what the IRS basically said, as did the Department of Labor. If you don't have a run-out period, or you have a shorter run-out period, then this is going to obviously limit part of the amount of time on the back end. But really, you do need a run-out period, and this is how it's going to have to be administered.
Okay. If the run-out period ended prior to March 1st, the tolled period does not apply, correct?
That is correct. If you've already finished your run-out period prior to March 1st, you have no issues.
Okay, so this extension would apply only.
Okay, go ahead, Casey.
This extension would apply only if the run-out period was still in effect after March 1st.
Exactly.
Okay.
So even if part of it was, so you had a 60-day run-out and you spent 30 days before March 1st, then you would still have the tolling period and then 30 days after the end of the tolling period. But if everything was completed before March 1st, you would not have any issues.
Okay. Are there any updates on extending grace periods to allow participants to use the funds for the CDHP plans?
We have not heard, this is not part of the grace period. Because basically what the law said with the tolling is it was for submitting of claims. It did not say for incurring new claims. And at this stage of the game, we have not heard anything from the IRS about FSAs. That's the biggest issue with the FSAs. And because the doctors and the dentists and everybody cancel appointments, especially for mid-year plans, and how they can use those funds. So no, this does not affect the grace period at this time.
Since they can't, can they reimburse taxed or non-taxed?
If you're talking about an FSA and you want to, and it's the use it or lose it, and the employee is losing the money, and it goes back to the employer. Technically, the employer is supposed to use the monies that they receive back from the employees for the benefit of the plan participants. And one of the ways they can do that is give the monies back evenly to all the plan participants, but not to the individual who might have lost more money. If you intend to give it back to the individual who lost more money, even on a post-tax basis, you should always document why you're doing it, that we've had the pandemic, that you're doing it in the best interest of the plan participant, and that you're certainly not trying to avoid any kind of taxes.
Thank you. If a plan completely shuts down because the business closes, what's the employer's responsibility?
If the plan completely shuts down and there's no plan left, then there's no COBRA.
All right. I think that kind of sums that up. If a claim comes in with DOS after the employee terminates, but has not elected COBRA yet, can the medical carrier still deny the claim? Or will they have to hold the claim until the election period is expired?
The guidance that we're getting is that they cannot deny the claim until after the period has expired. They're going to be holding the claims in abeyance. It's going to be interesting to see how that works and how all the coordination is going to have to be done so that they know who's paid, who hasn't paid. It's going to be a little bit of a mess to start with, but yeah, they can hold it in abeyance. But at this stage of the game, the guidance is they cannot deny it. And again, this is brand new. There might be some further guidance on this. We expect some more questions and answers from the DOL and the IRS within the next week. So far, they haven't put out anything else except the basic guidelines.
I think we may have mentioned this before, but a little bit more specific question about how these changes in election times for COBRA, how are they going to be communicated to the COBRA participants?
Yeah, and again, that's something that we're still trying to work through. We don't have any guidance from the Department of Labor on this yet. It's not part of the model notice that they just put out. So we're not sure how the individual is going to be notified, or if it's just a question that, you know, when they're late getting the premiums in, that you don't do anything and that they have this breakout period. We're still waiting more guidance, and we're still working towards the best resolution for the qualified beneficiaries and how to notify.
Okay. Will the employers be on the hook for paying premiums for those that delay paying their COBRA?
The employer should not be on the hook. And again, we're still waiting for further guidance. But what the IRS and the DOL has made clear is that the employee is still supposed to pay the premiums. They pay them back retroactively after the breakout period if they don't pay them all along. And that if they don't pay the premiums, then the coverage isn't there. So the employer should not be on the hook for paying the premiums. And again, the claims would be held in abeyance, and the insurance companies are going to have to accept these payments late. They have no choice either. This is a mandate. So just know that it's not the insurance carrier that can come up to you and say, hey, I didn't get the money within, you know, the 45 days of the 30-day grace period. Therefore, I'm terminating this individual. They are also mandated to continue the coverage or to hold it in abeyance until after the end of the breakout period, and then after the time that for the grace period or for the election period and the payment of the first premium. So the insurance carriers are also aware that they have responsibilities in this as well.
Okay. We still have several questions that we are going to answer here. I'm seeing some things come in, and I just want to go ahead and make a point of saying that we are going to send out the slide deck. We are going to send out the recording of this presentation. As soon as it concludes and is uploaded into our systems, I will try to get that out by the end of the day today, so you'll at least have some reference to kind of look back on. And as far as any flyers that are client ready with information on it, we are trying to get those put together with correct information, the most that we can provide to you, and have them out as early as the beginning of next week. So just wanted to go ahead and put that out there before we kind of go back into some of the questions and give Michelle a little vocal break there for a moment. But we do have several more questions that have come in, Michelle. Can we talk about how COBRA interacts with furlough situations? Are employees eligible for COBRA if they do not pay their premiums during furlough?
Okay. You know, that is a completely separate question that's not addressed in this seminar. Basically, non-payment of premium is always a reason to terminate benefits. Just as somebody who is on FMLA, and the arrangement that you made with them before their FMLA leave is that they pay their premiums or they potentially lose the benefit. And of course, with FMLA, there's some other special rules when they come back. But COBRA does not interact with somebody who is on furlough because they're still an active employee, and especially if you're an applicable large employer, it comes in with the ACA, but they still need to pay their share of the premiums. That being said, if I was an employer, I would always look at this is a unique situation, whether or not you're getting any monies from the PPP and whether you can pay your employees' premiums with that. There's a lot of different things that you should consider. But again, if somebody has a non-payment of premium in a furlough situation and it's not a COBRA situation, the extended period does not apply.
Okay. If the COBRA qualified event date is prior to 3/1, is also told, like special, I'm sorry, I'm not understand. I don't think I understand the question here. If the COBRA qualified event date is prior to 3/1, also told, like special enrollment and claims.
Okay. The answer is yes, even if the qualifying event happened before, as long as the periods are not completely satisfied. So, for an example, if the qualifying event was on February 1st and the COBRA letter went out on February the 5th saying that you have 60 days to elect COBRA, then that period of time in February that they didn't elect would be counted towards those 60 days. Then it would be told. And then 60 days after the end of the national emergency, whatever they had left over for that election would come in. So it doesn't say the qualifying event has to occur on March the 1st. What happens on March the 1st is for anybody who hasn't elected or who might even be a COBRA participant and hasn't paid a March premium, that period of time is told after March 1st. You just take it out of the equation. It doesn't exist.
Do we have any updates regarding COBRA in regards to the Workers' Health Coverage Protection Act?
I would have to look that one up. I'm not familiar with that.
Okay, I can go ahead. There are a couple that I'm going to go ahead and add to our next Tuesday's desktop discussion. And like I said, when the slides and the recording for this presentation goes out to the attendee list, I will also include the link for how to call in to the desktop discussion so you can get a few more answers to these questions. So does that work for you, Michelle?
It does. And just to let the audience know, we do have desktop discussions every Tuesday at 10 where you can submit questions on anything COVID related, and we will do our best to answer them.
Absolutely. And we'll send, like I said, we'll send all this information out after the presentation today. Will the carriers refund employers' premiums if the participant doesn't pay?
That you should talk to your carrier about, but the answer should be yes, but talk to your carriers. Because they also know that this period of time is told and that COBRA coverage will not pick up until the premiums are actually paid. So do talk to your carriers.
Okay. How will MedCom know that the loss of coverage is due to COVID-19 related reasons?
It doesn't matter if it's due to COVID-19 related reasons or not, as long as there's a termination and a COBRA qualifying event. It doesn't have to be related to COVID in order for this to kick in. This is because we're in the COVID situation. The government said that they're concerned about people losing coverage and they're not being able to afford it and having some issues. So they put this in for all times. You could have somebody who went off work last year and still within the 18 months of COBRA and paying the premiums, and potentially it was November, December of last year. Now his premiums for March are going to be told. So again, it has nothing to do with the COVID-related reason that they go off work. It has to do with this period of time during this COVID crisis is going to be told.
Regarding the COBRA notice for a new employee who enrolled a spouse in their plan, has the deadline been extended on when you have to mail the COBRA notice?
I'll have to look that up. I'll have to do some more research on whether, I think the COBRA notices might have some extensions, but not as much as we think. So I will look that up. But again, the whole idea is that the individual has more time to elect.
Okay, if the employee termination is not COVID, so the tolling period does not have anything to do with COVID-19 related terminations.
It does not. It has to do with any COBRA related event. It does not have to do with COBRA specific related events. This is because of the crisis that we're in. It's covering everybody March 1st to 60 days past the end of the national emergency. this period is blacked out. Doesn't matter the reason why you left work.
What happens if COBRA participant is reinstated without payments and they have claims and they end up never paying?
Again, the claim should be held in advance until the premiums actually get paid, so that it's not a pay and chase situation. So if they don't pay, let's say they don't pay, they're already on COBRA, they don't pay, they've got the toll period, and then in September they go back and they pay March and April, but they don't pay May, June, July, August. They will have claims paid for March and April, but the period of time that they did not pay the premiums for April, May, June, July, then they won't have those. Then they won't get those claims paid. So again, the tolling period doesn't negate the fact that in order to have the coverage, they have to pay the premium. It just gives them more time to pay the premiums while the claims are held in abeyance, waiting for them to actually do it.
Okay. Can you please restate the rules for run-out periods that ended March 31st? Also, does this apply to both FSA and HRA plans?
Yes. HRAs and FSAs, HSAs, it doesn't really apply to because HSAs is individual money, so it does not have anything to do with that. Basically, from March 1st to 60 days past the end of the national disaster being declared over, that period is tolled. So if you have a run-out period and it ends March the 31st, those 31 days in March are now tolled. And then after the end of a national disaster, you would have the extra 31 days in order to submit your claims that you've already incurred prior during the run-out period. If your run-out period ended on February 29th, then you're done, you're finished. But if it ended on March 31st, it gets tolled March 1st till 60 days past the end of the national disaster, then you would have the 31 days that you would normally have had for March to get your claim submitted for all the expenses that incurred prior to the end of the termination of your FSA or HRA.
Related to COBRA and the extensions, in the Tony example, she paid January and February, but not March. Do you go ahead and terminate her coverage for non-payment and then reinstate if payment is made?
No, you cannot terminate the coverage. This whole thing is tolled. It puts it almost in suspension or abeyance, but you don't terminate it. So if she paid January and February, that's great. Claims get paid. But between March 1st, which is when this breakout period occurs between March 1st and 60 days past the end of the national disaster, everything is kind of held in abeyance and then she would have the 30 days after that in order to satisfy the grace period in which to go back and pay all the other benefits. After that grace period is ended, after the end of the 60 days following the end of the national disaster, that's when you'll be able to see, okay, she paid March and April, so we're going to pay March and April claims. But she didn't, and she would have coverage March and April, and then it would be terminated. But she wouldn't have, because she didn't pay May, June, July, August, or whatever, then COBRA would have been terminated the last time that she paid the premiums. But during that period of blackout, that abeyance period, you cannot terminate anybody. They're just kind of held in suspension, waiting for the premiums and waiting for a decision. It's not a question of you terminate them and then you reinstate them. You cannot terminate them. They're sitting in abeyance. They're in this blackout period.
Okay, there's a clarification here. So the employer should not pay the COBRA premiums for the individuals while they're in the tolling period.
If the individual pays their share, it's still up to the employee to pay the premium. If the employer pays the premium, then that's potentially money that you've lost. The claims will get paid, and you potentially can go back and ask the employer for it. But if the employee doesn't pay you, then you could potentially be lost. So again, that's an employer decision as to what you want to do. Some employers are going to say, I'm going to cover the COBRA premiums. I'm going to do it. Others are saying, hey, because this is now like a blackout and the employee still has the opportunity down the road to pay the premium, I'm just going to let the employee pay the premium. The insurance companies cannot terminate the employee either because of the fact that they didn't pay during this period of blackout. The insurance companies are also going to have to wait till the end of the blackout in order to see what actually happens and if the employee pays the premiums and then go back and pay the claim.
For employees on FMLA who may not make payments, non-COBRA, the employer must continue coverage during the period, even if not paying, correct?
Okay. FMLA rules basically say, and again, there's a lot of state-specific FMLA, but the federal rules say that the employer cannot terminate the coverage of a medical benefit while somebody is on FMLA. However, they can still request the employee's share of the premium. And if the employee doesn't pay their share of the premium, then coverage can be suspended because they have not paid the premium. So it's always very important before somebody goes on to FMLA is to determine how those premiums are going to be covered. It's done in many ways. Number one, the employer can say, while you're on FMLA, I will certainly cover your premiums for you, and then when you come back from FMLA, then we'll take it out of your paycheck and get an agreement to that. One of the issues with that is that if the employee does not come back from FMLA and the employee doesn't come back for the reasons that they went out on FMLA, then the employer is barred from asking the employer to give the ex-employee at that point probably to give the premiums back. So again, that's a decision that the employer and the employee have to have. The second thing is that you can ask the employee to continue to pay the premiums on a monthly basis or a biweekly basis, just as you would if they were on the payroll. And if the employee agrees to that and they don't pay the premiums, you can terminate the benefits, but you have to give at least 15 days notice. So you always have to give at least 30 days to pay and 15 days notice that they didn't pay in order to terminate the benefits. So there's a whole bunch of rules that you have to follow. Then when the individual comes back from FMLA, you have to offer them benefits immediately again. And if they don't go back and pay the back premiums, then the claims that they had during the time that they were on FMLA are not paid. And then they move on to a new claims period when they come back. So the FMLA rules are very, very specific for FMLA and have really nothing to do with this blackout period.
Okay. If our team member's spouse gets furloughed with their employer, would this be a qualifying event for our team member to add their spouse to his coverage?
Repeat that one, Casey.
Sure. So I have a team member whose spouse was furloughed from their employer due to COVID-19. Is this a qualifying event for their team member to add their spouse to their coverage?
Not necessarily, because they would have had to lose the coverage with their spouse's carrier, and if they're furloughed and their ACA applicable large employer 50 full-time or full-time equivalents, they may not have lost their coverage, so it may not be a qualifying event to bring them on the plan. We'd have to look at all particular circumstances surrounding that.
Okay. What if you've already terminated someone for non-payment in March prior to this new information being released?
We'd have to go back and then reinstate the person basically for the blackout period. If the premium was due in March, if the premium was due in February and they did not pay February premium and they had already run out of the grace period in February, like February 29th was the end of the grace period, and then you sent them the official notification in March, then they wouldn't, that would not affect this blackout period or this outbreak period. However, if they didn't pay the March premium, then they would be entitled to have this reviewed, and at the end of the outbreak period, if they came up and paid the March, April, May, June, whatever premiums they pay, coverage would be reinstated. So it doesn't depend on whether or not the notice has already gone out that they were terminated. It depends on what the date of the event was and why.
Okay, yeah, they clarified after and just said terminated in April for non-payment of March, but you answered that question as well. So I think we're good to go on that one. Let's see. There's no way for carriers to know that they aren't paying unless we process the termination, which you said we are unable to do. It seems like the carriers would pay the claims and then have to reverse them all.
Yeah. This is where everyone is going to have to get some form of administrative procedures in place, because you're right, that's one of the issues with this whole thing. And I'm sure the carriers are going to start working on how they actually handle this, as well as the individual COBRA administrators. But this is one of the biggest challenges that we are going to face in the next couple of weeks as to how this gets relayed to the carrier.
As the employer, if I don't pay the premium, it's the only way to stop the premium being paid to the carrier.
Okay. I mean, yeah,
I don't think I understand that question.
Yeah, I can see what she's saying. If she pays the premium to the carrier, then the carrier is going to pay the claim. But if you don't have if the individual did not provide the money, then you don't have to necessarily pay the carrier, and then you wait till the end in order to pay the carrier. And again, as we said, with this whole law coming out, and it came out last week, and it does kind of fly in the face of how COBRA administration has been handled all these years. So there are going to be some challenges to work through and figure out how the carriers get notified that this premium hasn't been paid without the employer paying the premium out of their own pocket. So there's going to have to be some kind of communication network set up, and it is going to drastically change the way that we are handling COBRA administration. There's no doubt about it.
Okay, I'm going to try to piece this question together a little bit, Michelle, so bear with me. This is for a run out that ended on March 31st. That's 31 days. Is it 31 days after the end plus 60 days, or is it just 31 days after the end of the national emergency?
Okay. It's going to be, the breakout period is set in stone. It's the 1st of March of 2020 through 60 days past the end of the national emergency. So you've always got that 60 days. So that's the breakout period. Now, after that, because they were looking at the run-out period ending on March 31st, so there's 31 days in March. So after that 60 days, at the end of the national disaster being declared, then you would tack on that 31 days. So you would have the breakout period from March the 1st through 60 days past the national emergency. Then you would have the 31-day run-out period. Then you would have the end of the run-out period. So you're going to be going for 91 days after the end of the national emergency in that scenario.
Okay. If you cannot terminate coverage, then claims will continue to be paid. There's no way for carriers to hold that unless they're termed.
Okay. Again, this is going to be something that the COBRA administrators, the carriers, and the employers are going to have to work out, because you're not allowed to terminate them. So we're going to have to work out. And again, this is why it came up last week, and it's going to be a huge challenge in the COBRA community. But you can't terminate them, and you don't want the carrier to pay the claim until the COBRA gets paid. So the carriers, the COBRA administrators, and the employers are going to have to sit down and figure out how the carrier gets notified whether or not premiums were actually paid to this individual during this blackout period.
Okay. How do you advise the insurance carrier not to pay claims for Tony for March since she did not pay? She'll be on her employer's bill, meaning they are paying the premiums?
Okay. And again, this goes back to the whole thing that we just talked about. It's going to be that everyone is going to have to change some processes, most likely, determine what they're going to do, how they're going to do it, or whether the employers just want to pay the premiums and forget this blackout period. But again, decisions are going to have to be made. All I can do is say this is the mandate, and then the processes will have to be put in place in order to be able to handle the mandate.
Okay, let's see. Will MedCom be I think we've already addressed this, but I'll bring it up again. Will MedCom be communicating to carriers that members are in late payment status and that claims should be held?
MedCom is working out our processes as we speak as to how this will be handled.
Okay. All right, the deadlines for special enrollment periods under HIPAA are open-ended during this period until after the outbreak. Is that correct?
Yes, for the special enrollment rights during this breakout period, they're also in this blackout period, and then they can make their elections afterwards if they want. Yes.
Okay. And so then we must not apply any enrollment deadlines until after the end of the outbreak period.
Exactly.
Okay. I'm trying to kind of skim through these questions here to make sure I'm not double covering a lot of things. Does the runout extension because of tolling also then further complicate the rollover applying to the health FSA?
It does, because we're going to have to wait until after the end of the runout period in order to determine how much money to roll over until the next year. Yes. So it all depends on when the plan year ends. It's also going to affect reconciliations and everything at the end of the plan year, and how it's all going to work. Up until the end of the rollover, we will not know how much, the run out, we will not know how much to put into the rollover.
Let's see, is the employer required to notify employees of the additional time to submit runout claims? Do they also have to notify terminated employees?
You know, that is a really good question. And at this stage of the game, the Department of Labor and the IRS have not come out with any further instructions. They just gave us the outbreak periods and told us this is what they are, but they have not given us any guidance as to how to notify any COBRA beneficiaries, anybody on an FSA, or anything else. So at this stage of the game, we're still waiting for some more guidance.
Okay. COBRA, so the COBRA member may stay on COBRA during the pandemic without paying, and the employer has to pay the premium to the carrier since COBRA member cannot be terminated. Is this correct?
And again, the carrier cannot terminate them for non-payment of premiums. So we do have to get processes in place so that the employer doesn't necessarily pay the carrier. The carrier holds everybody in abeyance until the premiums actually get paid. Again, this is very new for COBRA. It's not the way we'd normally handle COBRA administration in the past because deadlines were very tight. But with this loosening of the deadlines, there's going to have to be some process change.
Okay, and we've got one more question. Rollover funds have already been rolled over for most January plans in early April. How does that work? Do those funds have to be reversed back to the prior plan year?
If we see at the end, you know, because you're right, most of the January plans, if they've had a 90-day run out, then there might have to be some adjustments if claims come in. If there's no claims that come in after the end of the breakout period, then that's fine. But again, there might be some adjustments to plans that ended on January 1st that had a 90-day run out.
For the FSA rollover funds that should not have been rolled due to this change, What if the employees have already spent them?
That's a good question. And again, it's only really going to affect those, I believe, that had a calendar year plan that had a 90-day run out, and it's already been reconciled, but we'll have to go back and look at it. And again, if they submit more claims after that, potentially the claims just will be paid because they've already got the rollover money and they've already spent it.
Okay. That's the end of our questions for today. It's certainly been a lot of information, and we understand that you know, there still maybe a lot of confusion out there. We just had one other question come in about you know, what will MedCom's process be if an employer submits a termination? Do we have that worked out yet, or is that something we're still discussing?
If they submit a termination, its process continues as normal at this time. It's just a question of waiting to see if the employee elects within the 60 days or whether we need to put it in. If he doesn't, then we can't terminate it until after the end of the blackout.
Got it. I will be sending out a recording of this, the slide deck, as well as the information for our Tuesday desktop discussion, where we do answer any questions related to the pandemic, COVID-19. So please be on the lookout for that information. We appreciate your time and attendance today. Michelle, thank you so much for all of the work that you've done to put this presentation together, to present us as much information as we know at this time, because there's still so much that's up in the air. We do appreciate you, and we appreciate everyone on the call today for being here.
And thank you, Casey. And just as a final note, as again, they've moved out cheese, as we talked about. They moved out cheese big time. And especially with the COBRA and how the carriers are going to be handling it and employers paying premiums. I mean, the whole idea of who moved out cheese was we have to get new processes and we have to look at it in a completely different light because of this mandate. So everybody's going to be working really, really hard to see the best way to do it. But definitely our cheese has been moved.
All right, thank you. And just one more note, I did get another question in. We will be sending the information out for the desktop discussions when we send the recording of the presentation and the slide deck. So we'll provide you as much information as we possibly can in as many ways as possible to get in touch with us to stay in the loop. Thank you guys so much. Michelle, thank you so much. We will be in touch. We are here to answer your questions when and however we can. Thank you again for your attendance and have a wonderful afternoon.
Thank you, Kate.